If you get the form that I'm suggesting I'll provide to you, then you'll see how it's set up. The way it's set up is categorizing assets. And they are the categories that are generally the way things are divided up in the practice manual form for an inventory. You know, it starts with real estate, all the real estate the folks have. We go to bank accounts. We have their brokerage accounts, the mutual funds, the investments and things. The tax-deferred accounts are listed there. And cash surrender value of life insurance, all of those types of things. And then we've got liabilities listed. And then after all of that, okay, that's all of the assets that these folks own together. Then we may have either below the line or on separate sheets. And when I say below the line, I mean below the line that says this is the net value of the marital estate, and this is what husband's value is and what wife's value is about what the division is. Below that would go the separate property of each of them, or what the people are saying is their separate property. And then if there's property that belongs to the children's property would go there. And so on the liabilities, typically we'll have credit cards, or most people, they owe some money on their cars or their house. I don't list those liabilities on down below. I list those up with the asset. Here's the car, it's worth $10,000, they owe $13,000 on it, its value is negative $3,000. It's all on one line, straight across. There's a column for the value, the column for the secured debt, the net value, and then who's going to get it out there on the right-hand side. One of the things that I have found in doing cases is that all debts are not the same. I'll talk about assets in a second, but all debts are not treated the same. For one thing, how much the lawyer has already been paid is not a debt. That is money spent. Okay, and so when you're putting something in regarding attorney's fees as a debt, it is what the lawyer is owed. Some people put everything that they've been paid as a liability down there on the attorney's fee section. That's a fiction, and don't make sure you check that. Don't let that happen. But the liabilities that are here, sometimes student loans, okay? If you've got a short-term marriage, 3 years during medical school, okay? And so they've got $180,000 owed for husband's student loans, and he's saying that's community liability, and so I should get a whole bunch of stuff if I've taken that liability. No. Yes, it's community liability, but I don't think the judge is going to tag the wife for that in that situation. She's not going to get any benefit out of it. Maybe she got some benefit out of it, but I would always argue, especially in a shorter-term marriage, student loans shouldn't be treated like other liabilities. Also, loans to family, they're real loans a lot of the time. If you even if the family doesn't expect to be paid back now, if the spouse that borrowed the money has siblings, there's probably going to ultimately be some accounting for that. In the settling of the parent's estate, if not before. But oftentimes I have seen debts to family dismissed, at least in mediations. I haven't had so much experience with that at the courthouse where judges just say, I'm just going to toss out the debt to family. But a lot of times in negotiations they're treated differently by the party not incurring the debt. Back up to the assets. Those are, I kind of think of it as a bowl of fruit, and they're not all the same. You can go and get an appraisal for a house, or you can use the tax appraised value, or just everybody can agree it's worth this amount of money. And then there's a liability, there's a mortgage on it and everything. And so let's say its net value on that calculation is $20,000, and there's $20,000 in cash. And so one person says, you keep the house and I'll take the $20,000 of cash, okay? Let's assume you weren't emotionally attached to the house, okay? Who in the room would prefer the house? Okay. Who would rather have the cash? Why? The cash is there, it's available, it's usable, you can do anything with it. And to turn the house into cash, you got to sell it. And you got to pay 6% to realtors of the gross sale. Okay, the net $20,000 house, the commission and the cost of sale could exceed the equity in the house. Well, that seems to make sense to me. That seems to be a fair thing. If you want cash for a house, then we ought to take out the cost of sale when we're trying to figure out what the house is worth. You don't know how many hundreds of thousands of dollars worth of hours of lawyers' time is spent arguing about that. And I mean, some lawyers just, if their client is not the one getting the house, they're going to refuse to negotiate that.
What if there's no equity?
What if there's no equity in the house?
Right.
Okay.
Okay,
so what about, so ignoring the cost of sale, there is no equity. Happens. Probably a lot of houses that are that way at this point, especially in other areas of the country. Then I would treat it as like you would the car that I just described. It's worth $10,000, but they financed 13 secured by it. It's got a negative value. Now, typically, what I've seen with cars at least, is they'll just treat them as having no value, not a negative value. Because there's an intangible value to having a car. It's transportation. But sometimes you can negotiate that. Brokerage accounts. This is a lesson that I learned from a lawyer who had learned it long before he met me. Most people have no clue as to the basis in each of the individual assets that they own in the brokerage account. Okay, and so this friend of mine did a deal where one party got all of the IBM stock, and the other party got the other stock. Well, there was a very high basis in the other stock, and there was very low basis in the IBM stock. So when the IBM stock was sold, there was a big capital gain on that. And there was no capital gain on the rest of this stuff. So even though they looked like they were worth the same on a brokerage account statement based on the value, the tax affecting of it made them be worth remarkably different amounts. And someone had an unhappy client. And so he went through that. He shared that lesson with me, so I didn't have to learn it the hard way. So, you know, if you don't know the basis, make sure that your client knows, unless we're going to divide everything in kind, every single investment in that account in kind, that you're risking getting hit with a capital gain. Or maybe there's a big loss that's an advantage to one person in getting certain stocks. So bear that in mind when you're going through that. Same thing with the tax deferred accounts, okay? This is another place where we spend lots and lots of time arguing, which can be saved if we divide them in kind, because then everybody's going to get the same tax effects someplace down the road. Some people don't want to tax affect the accounts, and then you got to argue about what should the tax effect be. The law says taxes can be taken into consideration, but that's about all that the law says, and it's something courts don't want to do. And so typically they're going to divide in kind to avoid the issue. And so just know that when you're going into those negotiations.